morning.
His Lordship Justice Anthony Mbuma, Her Ladyship Justice Dr. Procedural Freedom Gandhi, for HCC Petition E565 of 2024, Rigathi Gachagua versus State Law.
Gazelle. Where's the Quran? Where's the Quran file? Yes, Counsel Paul Mita.
My Lords, Your Ladyship, the petition number 565 of 2024.
Why do you have two counsels standing?
Good morning, my Lord.
Good morning.
Procedural presiding judge, my Lord Justice Milimani, and the lady judge. I am standing as the Attorney General, and I was going to raise pursuant to Attorney General's Act Section 7, which provides that the text is
Thank you.
I'm Dr. Segura, Attorney General, Senior Counsel. The Attorney General has also been sued as a party, and therefore representing the Attorney General is Professor Senior Counsel. Shadrach Mose, the Solicitor General. Emmanuel Vita, Deputy Chief State Counsel.
Emmanuel who?
Emmanuel Vita.
Where is he?
I'm present,
And Charles Muki. For the National Assembly, we have Eric Bumbo.
I'm present, my Lord.
For the Speaker of the National Assembly, we have Benson Milimo.
Before you, my Lord.
Josephat.
Yes, you are too fast, AG.
Sorry.
You introduced me some.
National Assembly, we have Benson Milimo.
Just for who?
Frioni. ONI. For the Senate, Edwin.
I'm present, my Lord.
And Senator Hilary Sigay. Muken
And Professor?
and Senator Hilary Sigay. For the Speaker of the Senate, we have and Peter Wanyama.
I'm present, my Lord.
For Professor Kindiki, yes, and DP Nomini, we have Mudomi Piankolu,
I'm present, my Lord.
Moses Kikoske, and Ken Lane.
Present. Yes. Leadership. In petition 565 of 2024, may I, at the very outset, before I state, counsel appearing, Deputy President applicant, may I, at the very outset, say that I am stating the quorum under protest. We are not willingly here participating, and we will elaborate. But that counsel appearing for the today before this honorable court appear under protest. They elaborate them later. I appear for Muite for the record. I appear Wanya.
Present, my Lord.
Wanjiro.
I am present, Lord.
Dave Wanjiro.
I am present.
My Lords, Your Ladyship, as I sit down, I seek clarity on whether it is only petition filed or whether it is criminal. I thank you.
So we take quorum on all the files that are before the court first.
Petition E015/2024 at Case Goya. Petitioner David Muni Mazembe and Father invited the National Assembly and President.
May it please your lordships and my lady 24, the quorum for the respondents is the same.
Just for the purposes of clarity, just I'll record the quorum.
The Attorney General. For the Attorney General is Professor Gideon Muigai, Senior Counsel, Shadrach Mose, Solicitor General, State Counsel, and Charles Mutinda, Deputy Chief State Counsel. For the National Assembly, Paul Nyamodi and Mugara George. For the Speaker of the National Assembly is Benson Milimo and Josephat Milioni. For the Senate, Professor Ojenza Moni Mukele Edwin for the Speaker of the Senate is Mercy Tanji and Peter Wanyama. For His Excellency the President, Adrian Kamoto. For Professor Kindiki, Mudomi Yankolu, Moses Kipkogei, and Ken Mele.
Your Lordships and Your Lordship, my name is Kipe Mongai, appearing in this matter with the following my Lord, in this matter, I appear with Senator Daniel Manzo.
Your name, please.
My name is Kibe Mugai. I thought I'd said it to you. Kibe Mugai. I appear in this matter, my Lord, with Senator Daniel Manzo.
Present, my Lord.
Mr. Ndegwa Njiro.
I'm present.
Honorable Jerry Maina.
Present, my Lord.
Mr. George Sankimpa.
Present.
Mr. Andrew
Mr.
Yes, oh, sorry.
We are recording.
You are recording. Sorry.
Can you start from Dan Manzo?
Dan Manzo, Mr. Leto Anjiro,
Present.
Senator How Honorable Jerry Maina,
Present, my lord.
Mr. George Sankipa,
I'm present, my lord.
Mr. Andrew Muge, Mr. Terahu Aduta,
Present, my lord.
and Mr. Kenneth Matiba, who is on the way, and Professor Ogada. Professor Ogada,
present.
and Kenneth Matiba is on the way. My Lord, we appear in this matter that continues to be referred as Kerugoya, petition number A015 of 2024 that appeared to have been filed in the same
You are here for which party?
we appear for the petitioners in that.
About your ladyship, this petition E015 2024, the Kerugoya file. Again, we appear for the first interested party, that is the Deputy President of the Republic of Kenya, in this E015. Lord, again, let the record capture and show counsel are as follows: Paul Mwite, Victor Soanya, and John.
Can we have that again?
Yes, I'm sorry. From both Faye Waigwa, George Wandati, and John. At the appropriate time, we will be going.
That I would like to be given before the hearing for
my lords, may you kindly equally confirm whether E0, one reason, your lordship, is that the bench was specifically constituted.
Thomas Kimozo Mwengi, petitioner versus Deputy President of Kenya, respondent.
Madam, that's what is necessary.
My lord, so my ladies, kindly with your kind for E567. That file was also coming up before you this morning. Same is before you. and if so, whether we can proceed with it.
When was it filed?
It was filed on the 18th of 2024. And it came up before Honorable Justice Mamuye, who gave directions that it will come up actually tomorrow. And I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today. So I also need clarification.
May it please the court. My name is Dr. Eboso. I'm a petitioner in E541. In which we got directions on 16. Directing that it be brought before the Chief Justice for this bench. Traces the same as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Mwangi, the second petitioner, notifications with regard to the directions in that file, because as we can see, there are files that were filed and which directions were given, and the bench was procedural. So we expected that the matter would be.
Lord, with utmost respect, and the record is very, very important. We heard the court assistant call out petition E1334, which you mentioned the one required. That is the file that was called out. And in order for the record of this code to be systematically accurate and easy to follow, may I, with respect, that we get clarity. File that was called out E13-24 of the lawyer. And perhaps it is for this honorable court.
So I've heard.
Thank you.
For the purposes of hearing this morning, the applications which are before the court are application which was consolidated in Kerugoya before it arrived here with E0114. Those are the three matters which are before this court. There are articles of our constitution of 13 and E014. Those are the files and petitions are here to reach us, but for the purposes of today's hearing, we have this.
That the number that is now registered in the matter that came from Kerugoya is added into the Nairobi files. And if so, then how do we appear that we have should be 560 as at Friday? Are we dealing with the matter in Kerugoya or Nairobi?
That file is not before us.
That's all I'm only saying. But I have instructions for the purpose of petition. All the directions in all these files, none of these files of ours are orders. The Deputy President-elect. The CJ could not have selected. There is impartiality.
Mr.
Yes, my lord.
Which this specific bench has been empaneled.
Thank you, my lord.
We do not empanel ourselves.
Thank you very much. The empanelment authority has had me now done.
Just a minute, Mr.
I think the 3 files which were filed in Kerugoya, that is 13, 14, and 15, those files, 18th of October 2024, this bench to hear those matters. They are filed online. When those applications were filed online, those are the ones which, very judge, that we will not be comfortable dealing here today. So I think we can now proceed.
Perhaps just to add that the numerous other not all the files have been transmitted to the bench. Maybe by the other files will have been transmitted to the bench. But as we speak now, here and now, these are the only files that were transmitted to the bench. Those are all the petitions there are. We don't even know whether the transmission has been done yet.
I believe now I can be able to make the clarification. We are starting with assuming quorum.
No, there's a quorum in E013, which was consolidated in Kerugoya.
Your Lordship, is terribly something wrong. You call the matters, E13 was not part of what was called. I have not heard, perhaps it would be.
What are you talking about consolidation? Nobody has talked about any consolidation. If you look at the record, you will find that the directions for to given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. Let us proceed from there. If you want to apply, as we speak now, there is no consolidation. The direction from this court was very specific on 3 different files.
My Lord, I'm not guided, but when Justice Rima was giving the whether the Kerugoya file has been integrated into the Nairobi system.
For record, matters which came from Kerugoya came with their with petition E014 of 2024, the same to be delivered in the Chief Justice.
So your was already consolidated. Those proceedings which took the petitioner in E014 amended petition on all parties. Similarly, the petitioner in E013 respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routine of 2024 may be filed in Kerugoya under the Kerugoya case structure, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E014, and petition number E013 are hereby consolidated. The parties who are here...
The Commission, Presiding Judge, the reason why all the files from Kerugoya is this. Going back, there was a specific order that because of the transmission, ETS, that is the contracting system, we had to the Deputy Registrar to formalize that. So there should be no cause.
We will then proceed and take quorum for the quorum on this matter.
Doesn't override my right to represent.
The only this has been stated, there was filed before impeachment, and they have no conservative letter. And they had no conservative letter.
So go to the matter.
My Lord, I'm leading a number of advocates in this matter from Kenyaga, E015.
Kerugoya 15.
Right. emanates against this general background. The first one, my lord, how that sitting occurred. With regard to that sitting, in an affidavit, in an application before you, that protesting amongst other things, that the sitting would be convened for purposes of hearing the fundamental rights is a practice that is prohibited under the 2010 Constitution. That's the reason. Could actually do that because she knows that. But we now learn, your lordships, that you are convened by the Honorable Lady Justice Wing, the Deputy Chief Justice. Lady, my lords, a legal issue and a matter of Article 150. My lord, under the law, we expected that the general, and that is what the orders implies, and required us to come on Thursday this week. A bench. She will do it in writing as required under Article 47 of the Constitution, because even when the sitting happened on Saturday,
my lord, may
I think I have a
just give Rafale Mungai time. Mungai.
I am Mungai.
Has, I believe, filed a so that the court does not hear speeches in vapor. So that even we taking notes know what we should be responding to. That's all I want.
Attorney General, I respect him, he was also my teacher, my professor of criminal law. But my lord, the point, I am acting for specific clients today, and that's the court. I should be having silence, he will respond. And our dedicated Milima has indicated we could not put it earlier in an application. So if I may post notifications, including in cases of a sitting by a bench has been on a working day, all applications. That is a substantive issue because of the second reason that our background that we are giving. Provide for the Bill of Rights. Under the former Constitution, under the former Constitution, where the Constitution, the state could conduct its business on weekends and outside court sitting hours to the orders made this time. And my lord, we are also sitting here pursuant to an order made by the Honorable Chief Justice. My lord, for purposes of Article 165, the powers of the Chief Justice to appoint a bench is a substantive power. The Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I said move this court immediately, aside that order on the basis of its unconstitutionality. The Chief Justice are formal applications. Issue number 2, applications to discharge that order made by the Deputy Chief Justice. That's what. Number 2, and it is implied in the applications for disqualifications. My Lord, that would be the case. That this issue is speak for the Wananchi and in the clear conscience. But that if that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are numerous of bias.
Maybe there is another issue that does not have to do with those papers. That cases that were supposed to appear before you.
There are about 4 matters. One of them in which I appear. And this is a fundamental issue. Application. Why for this bench to order all cases come on a specific day, this anxiety that somebody is speaking off record. For you over and over again, the repeated question has been the right to fair hearing, to say that we are going to conduct matters by installment.
Please, we should not bring the DCJ conduct at this stage, because I think
as I sit down, the issue of that right is that we have had a situation before the Senate, it didn't seem to matter. Before the High Court, my lords, I submit otherwise Article 25 would effectively have been amended to please the state.
I wish to make this clarification. The 3 matters which are before us today are not conservatory orders were issued per se. I have stated, and I'm repeating, conservatory orders. Subsequent applications were filed. The applications were those applications were filed online. And it is on the basis of only the application that we are here only to deal with the matters in which our attention. So kindly let us be as factual as possible. There is no issue about any of the things you are raising. We have to get out of this. There should be no problem. We are all here to defend the Constitution as a bench. Thank you.
Counsel Negua, you know, when you argue, like the way Mr. Mbe has argued, that courts what the new constitution filing system has brought to this country. So when you argue selectively, you mislead the people. You must be very neutral party. Let us hear also from the other side.
We haven't and Elisha will go this E01501. The orders at 4 p.m. When did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours. When did the Deputy Chief Justice sit in the middle of the night? These issues, for the sake of the nation, we are not just dealing, we are dealing about the president that will be set for the removal of deputy
presiding judge. I want to renew my request. We are now about to hear a second speech, a third speech, a fourth speech. There's an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. We can respond to it, but we cannot sit here all afternoon listening to speech after speech.
Let's be clear on this. The applications before this court we have stated which applications are in this procedure. We have to call any other file because when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the 3 files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, we can deal with it and dispose of it one or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, Your Lordships, on Article 165, on the constitutionality of the constitution of this bench, to hear these 3 specific files. And that is the issue, that the so-called empowerment of this bench, to hear these specific of Article 165 clause 4. It is our reading that the only capacity to empanel a bench is a Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel the Chief Justice, get the authority to empanel the bench. Was the Chief Justice present? 165 clause 4. What was the necessity of the delegation of this function? Those are pertinent that the Chief Justice, who is exercising delegated powers. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court filed with the lead file 522 have no reasons why they should be before him. Urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued summon us today, files are not considered as a priority, and the files with orders are the only ones that the court is sitting on a Saturday. The Chief Justice is empaneling, the Deputy Chief Justice is empaneling the bench. We are called in a lightning speed to appear before you. Because there are some orders that the state wants to vacate, you cannot run away from.
For the record, Dr. Kamoto for the fifth respondent in his opinion. I believe the reason we are here and the reason why we took forum is because we recognize so it would be abominable for a section of the parties to seek to colonize this process and treat them as if they are the only ones entitled to the orders of the court. So in this regard, my proposal is as follows, that each of the parties who has presentation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we are able to proceed methodically. And each party then, the court can then give directions how we move to treat each of those applications. Otherwise, we may be here indefinitely if it takes the opportunity accorded to make lamentations, to make speeches. We get an opportunity for each of the parties to ventilate the issues, because the fifth respondent has a pending application which is duly filed, a preliminary objection which even contests the jurisdiction to the nomination of a presidential over deputy president, which in our view lies squarely within the domain of the Supreme Court. So we once accorded an opportunity procedurally
counsel. And that's exactly why I wanted us to have how to ask me after all that, what is your application?
My application for which
just a minute. Well, what is it that you want us to do?
Under the Mutunga rules, that following the disclosure of the court this morning, that was that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165 Clause panel this bench. Your Lordship, this is the background of my application. That on the 14th of October 2024, did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file bill 522. And the files that were consolidated, Your Lordships, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application. Subsequently, other files, and the most important one is equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing for this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject to seek your guidance. My name is Muzomi, appearing for Professor Kindiki. Listening to my colleagues, he is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court provided whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuation that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations. I suggest again, and I beg the wonders, that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum and you keep making speeches upon speeches that have no bearing on the business of the day. The business of the day is not conducted. To the best of my knowledge, the business of the day there were applications on their side. There were applications an opportunity to come today to ventilate those applications.
Being invited to interpret Article 161 and one Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary, and you're being asked to for a long ride, and you're ending up wasting a lot of time in court. I wish you could go instead of beating around the bush, as you would say.
My Lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatic, the issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue way of the letter, it isn't anything that should take your Lordship's stand. That letter remains. They have written it to the Chief Justice. The Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My Lords, the previous report, 2024, before this bench was composed in panels on the 14th of October. My Lords, and today, as I've heard, our application has not been placed before you, my Lords and my ladies. So we're asking with the kind of indulgence, if you would please at least allow us time.
But the paradox, as I got it, because I don't make speeches, is that my colleagues accused this side of me. having said that, my Lord, and disclosures by the Lord Justice Mrema about how this bench has been constituted. It's now apparent that the first interested party in petition 15 have an issue with that. We suggest that we be given time when that application ought to be filed, a timeline properly constituted. Because if it turns out you are this will become secondary. Yes. But if it comes out that you are properly constituted, then the issue of recruitment.
Is that an adjournment? Is that if it's a lawyer applying for an adjournment? Because he's saying, and perhaps like the wrong say whether they're applying for an adjournment.
Is that palatable in this court, my Lord? I need that.
No, because
is that remark palatable before my Lord and my Lady? But because, you know, we have decorum at the back. Mark was there in your presence. I'm urging it to be withdrawn first. Then I can.
It is a veiled application for adjournment. Because Mr. Ngoya is saying.
He said he has no problem with withdrawing. I didn't withdraw. I want him to withdraw first, my Lord, because I'm entitled to dignity.
I have no problem.
Thank you. Let me now address the question. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. That matter requires a substantive application. Rightly, we are going most of it. Is therefore in that regard that my Lord and Mrema asked, Professor Kidu again asked, give back-to-back timelines on the compliance by the parties. Let the parties come and now.
Allow me, my Lords and my Lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrema. To tell the truth, because the issue of how this bench was empaneled has not, which was written this morning, while it was posted. Whether the file was actually, So they actually knew how the bench was constituted, and then possibly the only reason we should be given is why, so that the motion possibly is defeated by a function of time, which is what they are trying to do. The truth is this: can sit up to midnight without anybody questioning. So the issue of when the Chief Justice...
For the Speaker of the Senate, may we be heard? Listening to the speech, not an application made by the petitioner side, but not the framework in Article 48 of the Constitution. But when they filed an application to set aside those conservatory orders. Directions that those applications be had today. My Lord, under the Mutunga rules, there is a fundamental disputes, especially disputes that are of immense public interest. So, my Lord, no. But my Lord, at the same time, that constitution which requires to be read conjunctively says the Deputy Chief Justice our application to set aside the conservatory orders. My Lord, that will make more public interest. Thank you.
My Lord, if I may just add,
I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. On the validity of this bench to sit, this is the direction we are making. This court to sit must be filed within 1 hour and responded to